Yes, good evening. Thank you very much for taking your time to be part of today's training as well. We sincerely appreciate you for your commitment and dedication. And this training is brought to you by the Institute of Global Peace and Conflict Management. It's over close to 2 weeks now that we have started training on arbitration, and we are still on it. That is alternative dispute resolution, and we are still on it. And we are talking on the aspect of arbitration. That's why I mentioned arbitration anyway. But it's alternative dispute resolution. And people have been so committed, dedicated, and we are here today to continue with the training. So I want to welcome you specially on behalf of the Governing Council of the Institute and the management of the Institute for this training, and also to appreciate those of you that have taken your time to be sharing, inviting others to also participate in the training, because it's also helping us to reach to many people. And that is the only way you can contribute, and many other ways that you may contribute after the training. But in the process of the training or during the training, when you share the link with someone, share it on your walls, inviting others to join, you are also helping to spread the message. And it means that you are indirectly promoting peace. And so I want to appreciate those of you that have been so committed in sharing the meetings and all of that. Thank you very much. And we say that God bless you for doing what you are doing. Today, I want us to look at arbitration rules and procedures. Arbitration rules and procedures. We have been look at what arbitration is all about, processes and all of that. But today, I want us to look at some of the rules governing arbitration processes. All right, so that when uh, you have the need to use anyone, or you are going to any trade, business, or any form of contract, then you determine which one you should use. Do you understand? We have several of them available that you can use. So it's left for you to determine which one that is, convenient, which one that can fit into what you need. Do you understand? That is what we are talking about. All right. So um, arbitration is we say it's a process or it's a method of resolving disputes, all right, outside of the courts. This is what we have been saying, right? That arbitration is the process of resolving disputes outside of the court. And by so doing, it has various rules that govern the arbitration process. Do you understand? It has various rules that govern the arbitration process. And of course, we have those applicable arbitration rules that we're going to discuss here, or we're going to look at. One of the ones that are popular and commonly used are the ones that are adopted by the UCINTRA, or you call them United Nations Commission on International Trade Laws. Do you understand? That's what we call it UCINTRA or on central or which way. So now the on central arbitration rules, they were adopted by the United Nations Commission on International Trade Law. Okay, these rules are often used in international commercial arbitration. So anything that has to do with commercial or trade-related matters, these are the rules that govern the arbitration, most especially at the international levels. Do you understand? So it's the guidelines that the UCINTRA are provided that you can deploy. Do you understand? And then so let me give you a case study of or example of one of such incidences that you can apply this kind of rules. Do you understand? For instance, now we look at a multinational corporation and a government entity may agree to resolve their dispute under the central rules. Do you understand? On central rules, allowing for what a neutral arbitrator and a structured process. So now you are going into a trade with maybe, for instance, now maybe a company in Nigeria, for instance, want to enter into trade agreement with a company or with the government or UK, for instance. Do you understand? Basically, okay, for instance, now you can see, let me just make a revisal of the case. Now you can see we have uh, international companies, for instance, construction companies that are operating in Nigeria here. Let's take, for instance, Septrack, or take, for instance, Arab construction. Do you understand? So maybe they come in, do you understand? And then they have um, an agreement with, maybe say, let's say, for instance, the federal Okay, sorry for that, you know, obstruction. We had an obstruction. It came in. So we are looking at a case study of how or when you can apply uh, the ancestral arbitration rules. Or we say that, maybe for instance, now I was giving an instance, maybe let's say Arab construction company with Nigerian Ministry of Works. Do you understand? For instance, they will agree. So maybe in the agreement or in the contract agreement, they may decide to insert the ancestral arbitration rules. In case there's any form of agreement, these arbitration rules can be applied. Do you understand? The arbitration rules can be applied. And so they will decide who can mediate, who can come here, all of that, based on the contract agreement. Because in that agreement, there will be an aspect of the central arbitration rules that will be inserted. And that means that in case of any deviations, then these arbitration rules will be activated. Do you understand? That's how it works. That's why we say that the process of arbitration has to come with an agreement first. There must be an agreement, first and foremost. So when you are going to maybe international kind of trade or relationship with any company or with any government agency, and maybe we don't want to just go in like that. You make provisions, and you don't want to take your matter to court. Do you understand? You just make provisions that In case of any disagreement or dispute in the course of transaction or relationship, this aspect of the arbitration rules may be applied. Do you understand? So you state it in your agreement. So once there's a disagreement, that one will be activated automatically, and then you begin to use the rules you want. So you can decide which one. All right. So I just mentioned one. So we're going to another one. We have the ICC, that is the International Chamber of Commerce arbitration rules. Do you understand? Apart from the central, we have also the International Chamber of Commerce arbitration rules. It also administered by the International Commerce of Chambers. These rules are popular for international commercial disputes, just like the your central rules. Do you understand? Example, for instance, a contract between companies from different countries may stipulate that any dispute be resolved through ICC arbitration. Do you understand? Providing a framework for appointing arbitrators and conducting hearings. So, in case of any transaction dispute or transactional dispute, then automatically those clauses that border on arbitration will be activated automatically. Do you understand? In the contract, that's in the contract that you enter. That's agreement you have reached with whatever company or government agency that you are doing business. You made some provisions of the International Chamber of Commerce arbitration rules as some clauses in the contract that in case of any dispute, you will use it for such activation. Do you understand? So these are the issue. So you use it for such activation. So you use it, you activate it automatically. So let's look at another one. We have the London Court of International Arbitration rules. All right. We also have the London, so you can decide to use the central, or you can decide to use the International Chamber of Commerce rules. Depends on the one that fits your description on what you want and the kind of transaction you are going into, the kind of relationship you are going to have. It depends. Do you understand? So you decide it. You decide it. The parties involved will decide what they want. Do you understand? So we have the London Court of International Arbitration provides a set of rules for arbitration, emphasizing efficiency and flexibility. Do you understand? This set of rules, they emphasize what? Efficiency and flexibility. So that's what they emphasize. Do you understand? So example, for instance, now two parties in a joint venture agreement could choose London Court of International Arbitration rules to manage their arbitration process, benefiting from the established procedures for appointment and management of arbitrations. Do you understand? I hope you can hear me. So this is how you're going to use it. So two parties in a joint venture agreement could choose LCIA rules to manage the arbitration process, benefiting from the LCIA's established procedures for appointment and management of arbitrators. Do you understand? So you decide to use this one or anyone that suits your matter, the nature of business, the nature of trade. Do you understand? You decide which one. Then we also have the AAA, the American Arbitration Associations rules. Do you understand? The American Arbitration Association rule. This one is basically for domestic use. All right. All right. So these rules are commonly used in domestic arbitration in the US and covers various types of disputes. Do you understand? For instance, now it can be dispute over employment matters. Employment matters, it can be there may be clauses in the employment agreement or contract. Do you understand? That in case of anything or violation or dispute, you can uh, activate their clauses or use their rules to see how you resolve your dispute. Do you understand? Then we have the African Union rules. Although the African Union rules are not specifically arbitration rules, but there are rules that govern human rights abuses. Do you understand? So, in case of any such abuses, it can be activated. It can also help to, you know, to fit in the place of formal arbitration procedures. Do you understand? So the African Union has established the African Court on Human and People's Rights, which can play a role in arbitration. Do you understand? Related to human rights disputes, most especially human rights disputes. Do you understand? Cases involving violations of human rights by state parties may be arbitrated under these rules. And for instance, now if most of you can remember Charles Taylor, right? So such kind of human rights abuses, you know, attended to. So in this kind of, do you understand? So that's what happens. So now we have the East African Community, the EAC arbitration rules. These are regional rules, right, that govern uh, the affairs of member states in the East Africa. Do you understand? So if there's any business relations problems or transactional disputes among member states in the Eastern African region or bloc, they may decide to activate these rules, or they may decide to use the UCentral. Do you understand? The UCentral or UCentral, whatever, the UCentral rules to apply. Do you understand? So, for example, now business operating in the East African region or community, all right, can utilize these rules for disputes related to a cross-border trade. And you know, East Africa covers countries like which one? People should mention them. So they are there. Tanzania, Uganda, what do you call them? Zambia, all of them. Rwanda, all of them are East Africa. Do you understand? So these are the countries. So we have the Regional Center for International Commercial Arbitration. Regional Center for International Commercial Arbitration, RASICA, which based in Nairobi. For those of you that are in Kenya and you are joining this meeting, now you can go and verify. Based in Nairobi, Kenya, RASICA provides a platform for arbitration in East Africa. Do you understand? East Africa. So, for example, businesses in East Africa may choose RASICA rules for disputes arising from trade agreements. Trade what agreements? Trade agreements. So anything that has to do with trade, that is what we call them regional center for what? Commercial arbitrations. Do you understand? Anything related to trading, then you bring it here. So maybe when you are going to such transaction or business relationship, you may just put it in your contract that in case of any dispute, these are the rules we are going to use. Rules provided by what? Regional Center for International Commercial Arbitration. I hope you are following what I'm trying to explain here, because in international transactions or in business, you may decide to use domestic rules, but you can decide to use the ones that are internationally acceptable. Do you understand? Like the on central rules, they are generally acceptable, commonly used um, arbitration rules globally. Do you understand? So you may decide to use them, right? By the way, you can choose your own location where the arbitration process or proceedings may take place. So it's not a problem at all. You can even decide to use it in a domestic case. Do you understand? So that's how it works. So there are key considerations when you are choosing arbitration rules or any particular one. There are key considerations. So the choice of rules, for instance, now, all right, parties often have the freedom to choose the rules that best fit their needs, which can lead to more efficient resolution. Do you understand? So that's what it means. So you have the freedom to choose which one among the ones that I mentioned. These are the list. There are countries that have their domestic arbitration rules. So if it's a domestic matter and you don't want to use the ones that are generally acceptable globally, you can decide to use the one that are within your domestic or geographical location or jurisdiction, and then you apply and they solve your business problem. Do you understand? So, like for instance, now, let's take for instance a matter involving GTB and the innocent motors. Do you understand? So it was a matter that they took to court, and it lasted for how many years before it was resolved. So this kind of matters, this kind of business relationship, you can just activate an arbitration clause. Do you understand? In the agreement, in case of any agreement, because it saves you money, it saves you time. We have discussed the benefits of arbitration here, right? We discussed the advantages. We also, and the purposes of arbitration or alternative dispute resolution. We have discussed all of that. So you know the reason why we're talking about this thing. So instead of allowing you just going into agreement, not providing such kind of clauses, just waiting that in case you have a problem, then you take it to court. Then it means that you are giving room to spend more money, to waste time, productive business time that you can put into your business and get more profit. You are spending time going to court. Or even if you are not distracted to that extent, with the fact that you are taking your profit money and then you are paying lawyers to go to court every day and every now and then to represent you, it's a waste of resources. Do you understand? So once you are going into a business relationship, you can decide to activate arbitration process. Do you understand? In case there's any dispute, this form of rules, procedures should be applied. I think I have made my point clear and you understood me. All right. So, but you have the choice to choose the ones to use. All right. It depends on what you want and what you are dealing with. Then we'll talk about arbitration clauses. All right. These are the key concepts I'm talking about now. Contract typically include arbitration clauses specifying the applicable rules, the venue, and the governing law they can use. Do you understand? So I have explained it. I said it here just now. Enforcement. Many arbitration awards are enforceable under the New York Convention, under the New York What Convention, making international arbitration appealing for cross-border disputes. So you have any, whether you have a transaction with somebody in China, in America, UK, Germany, anywhere, there's no issue. You can apply them and they work for you. Do you understand? They work for you. They are effective. Nigerian government have paid so much several times based on all these contract issues. Do you understand? They are paid dearly so much, so many, several occasions. You know, our leaders are not always taking care of all those things. So sometimes they don't understand the implications. Do you understand? So before you know it, the renege on contract promises and agreements. Before you know it, in our recent, how many planes were seized? Is it true also? They were seized. I think it was in the news media because of some contract issues. Do you understand? So these are the issues. So let's look at the Central Arbitration Rules. That is the United Nations Commissions on International Trade Laws. Do you understand? So let's look at uh, the key features that surround these rules. What are the key features that surround these rules? We have the general framework, that is applicable to dispute arising from commercial relationships, whether international or domestic. So this particular rules, this set of rules, you can use them at the domestic level, you can use them at the international level. Do you understand? So parties can agree to apply these rules in their arbitration agreement. Do you understand? So in case of any transactional problem, either domestic or international, it can be applied. So they provide a general framework that you can use. Do you understand? Then appointment of arbitrators. So parties can appoint one or three arbitrators. You can appoint one or three arbitrators, but you can agree on what you want. But in case the parties cannot agree, the consensual provides procedures for appointing arbitrators. So it will guide you on how you can appoint your arbitrators. Do you understand? In case you're not able to decide on the number or the kind of person you should appoint, the essential make provisions, guidelines on arbitrators appointment. Do you understand? The procedures, arbitral procedures. The rules allow flexibility in conducting proceedings. All right. So arbitrators determine the procedures. All right, with parties given the opportunity to present their cases. So, like we said before, before you arbitrate, you provide procedures so that the parties involved will know what is at the stake. Do you understand? The parties know what is at the stake and they follow suit. Do you understand? So that's what it means. Then conduct of hearings, right? Conduct of hearings. Hearings can be held in person or via other means like video conferencing. All right. So yeah, it can, because we talk about the online arbitration procedures here, right? So you can do online arbitration. You must not necessarily travel. You can do business with somebody anywhere, and then you try to get to arbitrators and you meet online, discuss your matter and settle it. So video conferencing, like here like this now. If I like now, I'll bring you into the studio and we will discuss one on one and we'll settle our matter. I don't need to spend money booking flights to UK or somebody from UK coming to Nigeria or in a central location where we have decided that maybe we will resolve our case in France, so in Paris. So all of us, you are coming from UK to Paris, me, I'm coming from Nigeria to Paris. Do you understand? No, you can try to just do conferencing and resolve your matter easily. Do you understand? So, conducting hearings, but the parties may decide whether physical or online via any of the means that are available to them. The arbitral award. Award must be in writing and signed by the arbitrators. It must be in writing and the arbitrators must sign. Signing is a confirmation that it is, an authorization. It's a formalization that yes, this is legal and it can be tenable anywhere. It can be enforceable anywhere. So the award should state the reasons unless the parties agreed otherwise. Reasons. So confidentiality, proceedings are generally confidential unless otherwise agreed by the parties. And we told you instances where such confidentiality may be, compromised. Do you understand? We told you instances where there may be compromise. So it's possible that you may experience such situations. So compromising may be possible. Otherwise, strictly confidential. Then we'll talk about costs. Cost of the arbitration, including arbitrators' fees and administrative expenses, are determined by the tribunal. All right, are determined by the tribunal. So amendments, the rules allow for amendments and updates with the latest version being adopted in 2015. So it depends. If you have any updated rules, you can use them. There are some amendments, the ones, because in a process of arbitration, there may be procedures that may be changed. Do you understand? There may be new proceedings that you need to see and incorporate into arbitration process. So, by and large, you are saying that the central arbitration rules offer a comprehensive and flexible structure widely used for what resolving commercial disputes internationally, including Africa. So you can use it anywhere. Right? So let's look at the International Chamber of Commerce, all right, arbitration rules, right? Because the International Chamber of Commerce also provide a comprehensive framework for the conduct of arbitration, all right? So let's look at the latest version that was adopted in 2021, right? So let's look at some of the key provisions of ICC arbitration rules. What are the key provisions? You look at the scope and application, right? Applicable to any dispute arising from commercial relationships, provided the parties agree to use ICC arbitration. Just take note of this. Provided the parties agree to use, it gives you freedom to choose which one to use. You may decide to use the first one we discussed, or you will use this one, or you will use another one. There are several of them depending on what you want. Do you understand? So, but they must be what commercial related matters. International Chamber of what? Commerce. So commercial matters. All right. So commencement of arbitration. A party initiates arbitration by submitting a request for arbitration to the ICC World Secretariat. So if ICC was what you stated in your agreement or contract agreement, and there's a dispute now, what you need to do is that you need to initiate arbitration by submitting what? A request for arbitration at the ICC World Secretariat. Are we getting is the picture becoming clear now on the step you can take? So if you have chosen a central, it means that when there's a case, you are going to the United Nations, that is the New York Convention, you go there, and you go and submit your request for arbitration because they are the ones you cited. They want to use their rules. You understand? Then we'll talk about the response to the request. So the respondent must submit a response to the request within a specified time frame as been stated. Maybe you can take time, and because I'm talking now on the general procedures, do you understand? You can take time and look at the details of what I'm talking about here. Just make a research and look at some of the details of what I'm saying here so that you'll be conversant, so that you know the number of hours or the number of time or how long it takes for the respondent to respond. Do you understand? So you have to take time to know all of this. Constitution of the arbitral tribunal. So the tribunal can consist of one or three arbitrators appointed based on the parties' agreement or ICC procedures. Either you agree, if you refuse to agree, or you could not agree, ICC procedures provide how arbitrators will be appointed. So they will go ahead and use that procedure and appoint. Since you agree with their rules and you want to use their rules, there's a procedure for them to appoint arbitrators. So if you cannot agree to appoint your own arbitrators, they will go ahead and follow the procedure and appoint the arbitrators for your matter. So arbitrators, independence and impartiality. Arbitrators must disclose any circumstances that may affect their impartiality or independence. That's in case they are having conflict of interest, or they have any form of relationship with any party involved in the arbitration. They must declare it. They must say it. They must disclose it. Do you understand? Then arbitral proceedings. Arbitral what? Proceedings. The tribunal has broad authority to determine the procedure, ensuring fairness and efficiency. So parties may agree to conduct hearings in person or remotely. Do you understand? So that's what it means. So confidentiality. The arbitration proceedings are confidential unless the parties agreed otherwise or disclosure is required by law. So confidentiality. So interim measures. What are the interim measures that you can take? Okay, the tribunal can order interim measures to protect the rights of the parties before the final award. Because there are some cases that may raise tension. Do you understand? So in case there are such kind of tensions, the tribunal may decide to bring some measures that will protect the party or the parties involved so that no one will be harmed at the end of the day. All right. Arbitral award. The award must be in writing, signed by the arbitrators, and state the reasons unless otherwise agreed. Because there are some awards that may be awarded without stating the reason why this award was awarded, based on the agreement of the parties to the conflict or the dispute. Do you understand? We have the tribunal must also notify the parties of the award and provide a copy. All right, so that everybody will have the copy of the award. Do you understand? Even the person that is not going to benefit from it have a copy of it. This is the award. So cost, the tribunal determines the cost of arbitration, including fees for the arbitrators and administrative fees. All right. So parties may be ordered to pay a deposit towards costs at different stages of the proceedings. So that's what it means. So, but generally, as we have said, it's not expensive. It's not expensive when compared to litigation. Do you understand? So, expedited procedures. The courts, the ICC provides an expedited procedure for disputes with a lower value or where parties agree to a faster process. Do you understand? So emergency arbitrator. Parties can apply for emergency measure before the constitution of the tribunal through an emergency arbitrator. So in case the matter in question require urgency, all right, it's a matter of an emergency situation that needs to address immediately, you can apply for such an emergency arbitrator. It can be done. Do you understand? So multiple contract and parties. Provisions for handling dispute involving multiple parties or contracts are included, allowing for consolidated arbitration. Do you understand? Consolidated what? Arbitration. So where you have so many parties to the conflict, you can work on the consolidated arbitration and they all will be featured in and it will be done. So the ICC arbitration rules are designed to ensure efficiency, fair and effective resolution, efficient, fair and effective resolution of disputes, right, while providing flexibility to accommodate the needs of the parties involved. So that's how the ICC arbitration rules are being specified. So if you want to use it, you want to use your central arbitration rules, you can use. You choose the one that best suits your interest. Do you understand? You choose the one that best suits your interest. But you should, you should include it. There should be a clause in your agreement or in your contract, except you want to take the matter to court. We have the International Court of Justice, we have the International Criminal Court. Do you understand? They are there. But if you want to use arbitration, that's in case you don't want to take your matter to court. In the process of signing any contract, put arbitration clauses citing ICC or the central arbitration rules. So in case of dispute, you can apply requesting for arbitration. Do you understand? At their own secretariat, and you get a response, and then the tribunal will be constituted, arbitrators will be appointed, and then proceeding with start. That's how it works. I think the picture is becoming clear now. We're just talking about the benefits and the advantages and all of that. But now you are seeing how you can take steps, right? You are seeing what you need to do in case, or if you're going into international business relationship, don't just go like that. Don't just go like that. Do you understand? Let there be a cross in case you don't want to go to the court. If you want to go to court, you may leave it like that, or you may say in any form of disputes, the court may intervene or the matter will be taken to court. But I think I'm beginning to enjoy arbitration now. Maybe anytime I'm going to enter into any business relationship with someone, instead of saying that if all of these options or this are not obeyed, then I'll take the matter to court. Then I will say I'll take to ICC arbitration rules. I think it sounds better like that. So that when there is a problem, you are not going to court. You are going to an arbitration this thing. Do you understand? So that you can resolve your matter easily. That's what it means. So please, if you are following and you feel it's like people are saying it's becoming interesting, if it's becoming really interesting, then invite someone to join you to enjoy what you are enjoying as well. Let's move forward. Let's move forward. All right. So let's look at arbitration procedures. Arbitration procedures. Arbitration procedures are the steps followed during the arbitration process to resolve disputes. All right. So why specific procedures can vary depend on the applicable rules like the ICC, the Central, or others. The general process typically includes the following stages. So these are the stages that you are going to use in the arbitration procedures. There's what we call the pre-arbitration stage. Pre-what? Arbitration stage or pre-hearing, for instance. Pre-arbitration stage. Under this, what do you need to do here? First and foremost, you are going to do what we call arbitration agreement. You are going to sign what we call what, or draft what we call arbitration what agreement. So parties must have a valid arbitration agreement, which can be part of a contract, which can be part of what? A contract. Which can be part of what? A contract. I told you that you are signing the contract, you can enter some arbitration clauses there. So it can be part of that contract, or you have a separate document, determining how dispute will be resolved. Do you understand? In this country. Another thing that you need to do under pre-arbitration stage is notice of arbitration. Notice of what? Arbitration. After the agreement, the next thing is what? Notice of arbitration. The party initiating arbitration submit a notice of arbitration to the other party and the relevant arbitration institution. Do you understand? You submit to the other party and then you also submit to ICC or the Central. Do you understand? So that they will know that you are going arbitration. You are activating the arbitration clauses that were in the contract, right? So you can decide to use it for tenancy. Instead of using tenancy agreement, so they are by tenancy agreement, you can decide to use arbitration to resolve tenancy problems. Do you understand? Instead of saying that you go to court over and then tenants, if you start to pay rents and all of that, it can be resolved out of court. Do you understand? It can be resolved out of court. So commencement of arbitration. After you initiate arbitration proceedings, what happens? You commencement of arbitration. So under this, you are going to request for arbitration. All right. After the notice, you are going to request for arbitration. The initiating party files a request for arbitration, which includes details of the disputes, the parties involved, and the relief sought. Do you understand? So, and the reward you are looking for. Do you understand? That is, at this stage now, when you are requesting for arbitration, what are you doing? You are presenting the matter to court. You are telling the arbitration tribunal or the the institution want to use their rules that, okay, this is what happened. We enter into the social agreement and we agree so that, so like, okay, government, okay, the government of Nigeria through under the Ministry of Works, that, okay, this road construction is going to be for 6 months, and we were not mobilized, so we used our own money to do the work. At some point, we needed a kind of reimbursement for us to continue with the work, and the government now did not give us the money. So at that point, it affected our operation, and then the contract will not be completed at the time schedule. Do you understand? And as of course, in Nigeria, where the economy is not stable, where the cost of things change overnight. All right. Even when you go to the shop to buy something now, you just change your mind. I will not buy. It's too expensive. Let me go. But why going? You say, well, if I don't buy, where will I buy? Let me just go and buy it. To come to tell you the price has changed again. Oh, and it has increased. Do you understand? So that's how price works there. So, and then you explain all of those things. Do you understand? And how this affected the cost of the project itself. And so now you are asking that because government delayed in releasing funds, then the project cannot be completed at the amount it was earlier awarded. Do you understand? So it means that government will have to give extra more money. So that's what you are sorting for now. That's what you are asking for. Now you are asking for the extra cost of the project based on the increase in the materials and whatever that is involved in constructing project. Do you understand? So you are requesting and you are stating all of these details now. Do you understand? I'll just give you one instance. You are requesting and you are stating all of these details in the request now. So respond to request. That's another thing under the commencement of arbitration. The responding party submit a response to the request for arbitration, addressing the claims and any counter claims. Now, you have said your own side. They will also say their own side. Do you understand? And what is involved, or what was agreed, and how it was agreed, whether you were to use all the whole money and complete the project and then you come for reimbursement or not. You know, sometimes government, state government, I think it happens under passenger administration. We have state government construct federal government roads and come for federal government to reimburse them. Do you understand? But nowadays, but you know, it used to take, they used to go to court. So it used to take several argument and years of this. So many state government now, they don't want to take that kind of risk because they don't want to go and hire lawyers to go and fight for us because we construct federal government roads. Do you understand? So many state governments are not doing it. That's why federal government roads are very, very bad. You can see the one going to Lagos from Kogi to whatever. It's very bad from Makodi to Enugu, all of that. Very bad roads from Makodi to Kasinara to Taraba. Very bad roads. Do you understand? So because state government don't want to involve the one going from, if you can, if those of you that are going to Kwara, from Kwara, that is in Bida, from Bida, Niger to Kwara, very, very bad. And so, but state governments are there. They don't want to do it. Why? Because they don't want to bother themselves on hiring, you know, lawyers go to court and fight for us for a reimbursement. You understand? So all of these kind of things. But they will also respond. So whoever party that is involved, I'm just giving you instances, they will respond and all of that. So constitution of the arbitral tribunal. Constitution of what? The arbitral what? Tribunal. Appointment of arbitrators. Depending on the agreement, 1 or 3 arbitrators are appointed. The process may involve direct appointment by the parties, that is, parties themselves appoint the arbitrators they want based on their qualification and experiences and their knowledge in the area concerned, or appointment by the arbitration institution, which is maybe ICC or the Central or the RASECA. If the parties cannot agree, that's one. But another thing is Confirmation of arbitrators. That is, arbitrators must confirm their independence and impartiality. They have to state, I have no interest in the matter. I have no formal relationship or any form of relationship with the parties involved. I have not, some of them will even say, I have not known them before. I'm just seeing them and their matter for the first time. Do you understand? So I'm as neutral as anything. I'm as independent as the case itself is. So do you understand? So that's what it means. So preliminary conference. So after all of this has been constituted, what do? You organize what we call a preliminary what conference. What does this conference does? That's a case management conference. That's a preliminary meeting may be held to discuss procedural matters. They will tell you these are the proceedings, these are the processes, and these are the governing rules. We will talk about the rules the other day, right? Right. So we'll talk about the Vegas rules, Chatham House rules. All the rules governing arbitration will be stated. The processes, do you understand? Will be stated. Establishing timelines. The timelines where you're going to take 2 months to complete this arbitration, at most 2 months. Do you understand? Maximum or minimum of 1 week, maximum of 1 month to complete this process. Do you understand? So that will be stated so that everybody know the important timelines to work with. And set the agenda for future hearings. So that's what they're doing. So, and then they will determine, okay, if we cannot finish in so week, we'll extend it to another week to see whether we can cover it. Do you understand? So writing pleadings. Writing what? Pleadings. So statement of claim. So the claimant submit a detailed statement of claim outlining the facts, legal basis, and evidence supporting the claim. Do you understand? So you are requesting for arbitration, you state your facts, you back up with the legal basis of proceedings, and then you also support it with certain evidence, maybe document of the contract that you have signed, that this is what the document says, and this how the party signatures and all of that. Do you understand? These are your evidence, and the time the contract was signed and all of that will be reflected in the document. Then statement of defense. So the respondents submit a statement of defense responding to the claims and presenting any counterclaims. Do you understand? So if you have contrary document or opinions or evidence or argument, you submit it. So that's what it means. So document production. Document production. Disclosure of evidence. That is, parties may exchange relevant documents and evidence either voluntarily or through tribunal orders. Tribunal can order, or you can voluntarily bring the documents that are of concern and related document to the case. Request for further production. Parties may request specific documents from each order if necessary. Okay, you say we have signed the contract, bring the contract document. Do you understand? Maybe, for instance, now, maybe when the other party was delaying to release funds, maybe you write a letter to them, reminding them of the time frame of the project and the implication of delays. And then you let them know that as they are delaying, and the cost of materials is also increasing. So they should know that if they continue to delay, it will affect the timeline for the project and all of that. So if you have such kind of document, you also present that when you were suspecting that this may the party A may not be able to meet up, you wrote to them that they should not waste any time further because these things, the economic factors are not being favorable. They did not respond. You tender the document again. And maybe you have an acknowledgement copy. Do you understand? You show the acknowledgement copy. You say the original design. And so all of this document will be stated and be submitted. Do you understand? So that is its request for further production. So if there's such kind of document, to bring them out. Do you understand? So hearings, oral hearings. Hearings may hold where parties present their cases, including witness testimonies and expert opinions. All right. So examination and cross-examination is another aspect on the hearing. So witnesses may be examined and cross-examined by the parties. You understand? So that's what it involves. So post-hearing submissions, closing statements. After hearings, parties may submit closing statements summarizing their positions. Say, the tribunal, what's your position? This is what I want. Based on this, it's affected our operation, and of course, the cost of the project has tripled. So it means that government or the party involved will pay you twice of the amount you agreed upon earlier. Do you understand? So this is what it means. So deliberations and award. So deliberations, the tribunal deliberates on the evidence and arguments presented before reaching a decision. So issuance of what award? The tribunal issues a written arbitral award, which includes the decision on the merits and any order regarding any orders regarding the costs. Do you understand? If there are any costs, they will ask you to pay so costs, whatever. Then post-award procedures, right? Notification. The award is communicated to the parties. Enforcement. The award can be enforced in courts, typically under the New York Convention or other relevant treaties that are available, and most especially if it's an international matter. Do you understand? So that's what it means. So that's what it means. That's what it means. So possible challenges. Possible challenges. Appeals or annulment. All right? Appeals or annulment. Some rules allow for limited challenges to the award. In specific circumstances, you can challenge the award. And such, that's in case you have such provisions, that you can appeal for it. You can challenge it. Do you understand? And it's possible that it can be annulled. Do you understand? Or it can be affirmed. Do you understand? Either it's annulled or it's affirmed. So usually on procedural grounds. So where there are procedural issues, that is the process was not followed duly, it can be appealed. Do you understand? And of course, it may be annulled. All right. So the arbitration process is designed to be flexible and efficient, allowing parties to resolve disputes without resorting to lengthy court proceedings. The specific procedures may vary based on the arbitration rules chosen. Choose ICC or on central, it depends, but the general stages outlined here provide a framework for understanding how arbitration typically follows. Do you understand? So that's what it means. So let's look at arbitration award. And this is what we're going to look at lastly for tonight. Arbitration award. I hope you are following. Arbitration award. So now arbitration awards are the decisions made by an arbitral tribunal at the conclusion of arbitration proceedings. These awards can vary widely in their content and implications, depending on the nature of the disputes and the governing law. So that's what it is. So whatever awards may come in different, like there are some criminal cases that, though it's a criminal case, but the awards come differently. Do you understand? Sometimes they say you should spend 1 year in prison and also pay a fine. Now 500,000. Do you understand? Spend how many years? 1 year in prison and also pay 500,000 fine. Now there are many cases that you have like okay, an option of spend 1 year in prison or spend 1 year in prison or pay 500,000 fine. So once you pay 500,000 fine, it means that you are not going to spend 1 year in prison. Do you understand? That's what it means. So the award may depend on the nature of the dispute and the governing law. Do you understand? So what we are going to look at here now, I want us to look at some of the case studies. These case studies are fictional case studies. So don't take it to be serious. They're just to guide you. Do you understand? So even if we hear names, even names of countries, names of companies, they may be true names, but consider it to be what? Fictional. Do you understand? So that nobody will come and say, why are you using my name here? So let's look at when was this case happen. So these are fictional, even if the name sounds real. All right. So that's what it means. So case study, ICC case study number 1, 2, 3, 4, 5. ICC case study number 1, 2, 3, 4, 5. All right. Like I say, the fictional example. So parties. Now, this case, we are looking at the parties now. Who are the parties involved in this case? That is ICC case number 1, 2, 3, 4, 5. Who are the parties involved in this case? This is what we want to look at first. So a multinational construction company and a government agency are the parties involved. A multinational construction company and a government agency are the parties to this case. Are we following? What is the issue? After you find the parties, what is the issue? Dispute over delays and additional cost in a public infrastructural project. Dispute over delays and additional cost in a public infrastructural project. That is the issue. Award. The tribunal awarded the contractor an additional $10 million for delays caused by the government's failure to provide timely approvals. The tribunal found that the contractor acted in good faith and mitigated losses. You understand? Implications. This case highlighted the importance of clear contract terms. Clear contract terms. So that's why we say in the arbitration, the language, when you are writing the arbitration agreement, yesterday we said the language should be what? Clear. Use clear what? Language. No ambiguity. No ambiguous words. Do you understand? The language should be what? Clear. We said it yesterday, right? So the language should be clear. So this case just signifies the importance of clear contract terms regarding delays and the necessity of timely communications between parties in a large project. All right, that's the case study number 1. You see how it went, right? So if you are in government or you are a company, you give somebody contract and you are delaying, and maybe there are this kind of agreement or clauses, then there may be problem. Even employment contract can also happen, right? So let's look at case study number 2 on central arbitration. Now the other one to talk about is what? Is ICC. Now we're going to use on central arbitration. So we're looking at a case study of BG Group PLC versus Argentina. BG Group PLC versus Argentina. So parties, these are the parties involved in the case. BCG, BG Group, a British energy company, and the Argentine government. All right. So what is the issue? BG Group claimed that Argentina violated a bilateral investment treaty by imposing regulations that harm its investment. So now there is a bilateral agreement, for instance, now. Let me give you the implication of what, like the Federal Ministry of Education, what they did to universities in Benin Republic. Do you understand? Nigeria may have such kind of bilateral relationship, and that's why we told you that thing was a diplomatic problem. Do you understand? Can have a lot of consequences. So by so doing, the government, that's the company, claimed that after the government entered into a treaty which is supposed to protect the company, the investor, do you understand? And now government is now bringing a regulations that is going to affect that business operation in Argentina. So the company now is claiming damages. Do you understand? So that's why it files an arbitration. So now a request for arbitration. Award. The tribunal ruled in favor of BG Group, ordering Argentina to pay damages of approximately $185 million. The tribunal determined that Argentina's action constituted an indirect expropriation of BG Group's assets. Do you understand? So this is what it involves. So implication, this case underscored the protections offered to foreign investors under international treaties. Do you understand? The protection offers to what? International investors under what treaties, international treaties, and the potential liabilities for states that change regulations affecting, investment. So once you have international investors, and there is any international treaty covering those investors, and then you suddenly woke up one day and then decided to make a policy or a regulation that affect their operation, I'm telling you, you are going to pay for it. That's in case there is any arbitration clauses regarding that matter, you pay for it. Do you understand? Pay for it. Let's look at case study number 3, London Court of International Arbitration Award, Eurasian Natural Resources Co. versus Kazakhstan. Parties, Eurasian Natural Resources Corporation and the Republic of Kazakhstan, and then issue ENRC claimed that Kazakhstan had failed to honor obligation related to a mining contract. Do you understand? So the tribunal awarded ENRC $140 million for damages and asserted that Kazakhstan's actions were unjustified and violated the terms of the contract. So implication in this case illustrates the risk that states face in renegotiating or altering agreements with foreign investors, especially in extractive industries. And see, even our country here, they have paid share, and some of them so many damages. Do you understand? I think some of you must have heard such kind of story. I don't want to go into details, but these are some of the things that used to happen. When you hear them in the news, they did not just originate at the time you are hearing it. At the time they were signing contracts, these things were stated. Such clauses, such international treaties protecting the international electors were brought into limelight, and they were cited in those contracts. So in case of anything, because this is business, anything can happen. Do you understand? And then people will begin to bring stories that, and most especially in the extractive industry, you see a lot of things happen. Do you understand? So we bring it out and then favor them. Case study, SCC arbitration, Kuwait Airways Corporation versus Iraqi Airways. Kuwait Airways and Iraqi Airways are parties to this case. Issue dispute over the value of assets that were taken during the Gulf War. So award, the tribunal ordered Iraqi Airways to compensate Kuwait Airways for the loss of aircraft and other assets amounting to several $100 million. Do you understand? So implication, the case emphasized the enforceability of arbitration awards in international disputes involving state-owned enterprises, as well as the challenges of recovering assets post-conflict. Do you understand? Recovering assets post-conflict. After the conflict, what happened? Do you understand? There are so many things that need to be recovered. And then, of course, these things are enforceable at the international uh, community, right? So whether it's state-owned enterprises or state versus private-owned institutions, it can be arbitrated. Do you understand? It can be neatly arbitrated. Case study: SIAC arbitration. That is Tsinghua University versus Wenzhou University. Tsinghua University and Wenzhou University, both from China, all right, dispute over a joint research project and the allocation of resulting intellectual property rights, right? So the tribunal ruled in favor of Tsinghua, affirming it claims to a majority share of the intellectual property generated from the project, along with a financial settlement. So you put resources together, you conduct a project, the results and financial awards or financial benefit that accrues to the project. So who will take the lion's share? Maybe that's where the problem was. Do you understand? So at the end of the day, maybe the Tsinghua University put in more effort and put in more resources, so they have to take more of it. Do you understand? And then maybe someone was claiming that we should take equal, since we're going to you understand? So implication in this case highlighted the importance of clearly defined intellectual property rights in collaborative research agreements, especially in academic settings. Right? So that you not go and do work together and then somebody will come and claim it, or somebody will just over the night bypass you and use it and then put his own right there and say he's the owner. Do you understand? It's possible that you go into research work with someone and then you finish discover that the person say, I am the one that have done it. Then you become, you understand? All together then. So this is how it happens. So now I think you have the knowledge on how arbitration is being used domestically or internationally, involving government. So if government take your matter or government is involved, don't be afraid if you know what you did in the first place. So if you want to sign contract with government, don't just go and sign like that. Activate some of these clauses. We don't want to go to court. But you have so much money that you want to go to court, it's left for you. But you can still use this and to serve the purpose without necessarily going to court. Do you understand? That's what it means. Altogether. So this is the much we can take for today. Somebody's giving us an instance here. Somebody's giving us an instance here, and I want us to look at it. It said the recent case involving some Nigerian government presidential flight, right, and construction company that signed a contract with Ogun State government. Yes, so it shows that people are aware. This was a matter, okay, a very, very serious matter, and it was in our eyes here. Do you understand? So these are the issues. So I'm just in your comment section. I just want to see the comments people are saying here that will add more value. Yeah, you can see all of those proceedings, but at the same time, I have just given you um I'm still going to give you the manual, all right? But at the same time, you can go and take some of these institutions I have mentioned and look at the arbitration rules and procedure, the governing laws and everything. You can just take time. I just give you a brief guideline on how these things work. Do you understand? So it's not only for you as a student that can research, the student that have interest to become a, maybe some of you later you become members of the institute, and then we will certify you as a global arbitrator. There are some of our members that have been certified as global arbitrators. Do you understand? So, and then if you are certified as a global arbitrator, it means that you can arbitrate anywhere in the world. Do you understand? So, maybe tomorrow you become a member of the institute and you choose that. So, it's left for you now. I have given you the guide, as I have mentioned some of those institutions, and I say some of them are globally used, like the Central or the ICC. You can take their own, at least even if those ones alone. And if you want to research on domestic ones, you can still research, but you can use these ones and then study them comprehensively. Just look at it thoroughly and then understand what is involved. I think it will help. Do you understand? You may even look at example of such cases that have been drafted, then it will help you. But for this manual, I'm going to give you anyway. I'm going to give you so that you can still go through them. Any other question? Any other issue? If there's none, tomorrow we okay. All right. Thank you very much for being part of today's meeting. By tomorrow, we'll be looking at the international arbitration. And then also we'll be looking at the overview of international arbitration. We'll look at the role of international institutions in arbitration, as well as ICC and ICSID, then recognition and enforcement of international arbitration awards. So this is what we'll be looking at tomorrow. So take your time to be part of tomorrow's training so that you can see, gain more knowledge on how to go about these things. So, and then you should also be preparing for some kind of simulation practices and all of that, because very soon, once we are done with Lagos induction, you will have time to do simulation and do other activities. So we are going to group most of you that are consistent, because I don't want to select somebody that may not appear. So we are going to select people that are consistent to participate. Do you understand? In the simulation. So you can come into the studio and practice. You can come and demonstrate how you can address this issue, how you will take steps to address a particular matter like this, and what is expected, or when it's come to drafting agreement, what do you need to do, and all of those things you will come and demonstrate it. Let's see how it goes. Do you understand? So just prepare your mind, and that's why you should research and see some of the things so that you can be able to demonstrate it very well. So just prepare. By next week, we'll start doing that. We'll group you by over the weekend so that by next week, we'll start seeing what we can do. So thank you very much. See you tomorrow, same time tomorrow. Bye.